Welcome to the latest episode of Risk Settlements podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar on the latest trends and developments in the world of class action and other types of commercial litigation. I'm your host, Kevin Skrzowski with the litigation consulting firm Risk Settlements. And today we'll be discussing the recent increase in food labeling litigation that we're seeing all across the Midwest. I'm very pleased to be joined by John Zabriskie, a partner and trial lawyer with the law firm Foley and Lardner. Good morning, John, and thank you for joining me today.
Thank you, Kevin. Good to be here. Thanks for having me.
Of course. John, let's start by having you just tell us a little bit about your career, your practice, and the types of matters that you litigate.
Sure. Well, as you said, I'm a trial lawyer. I'm a partner in the Chicago office of Foley and Lardner. I'm kind of unusual, I guess, in the sense these days that I've been here or at a predecessor firm since law school, which was more than a few years ago. In my practice, I defend food labeling cases and other consumer class action matters, such as TCPA cases. And I also do a fair amount of work in the healthcare space, representing third-party administrators and similar companies.
Very interesting. Now, you recently wrote an article that was featured in Law 360 titled, Parsing the Recent Surge in Midwest Food Labeling Litigation. What changes in filing trends have you seen from, let's say, 2020 through the first part of 2022 with regard to food labeling litigation being filed in California and New York, which traditionally have been the number one and number two food courts, and the surge that we're now seeing in the Midwest?
As you mentioned, food labeling, misrepresentation, class actions are filed everywhere. Historically, California and New York have seen many of those, and they continue to. But my co-authors in the article, Ryan Lowry and Zach Kumar of Foley, and I are based in Chicago. So we looked at the federal court filings in 2021 in 8 Midwestern states. And, over the years, the Midwestern jurisdictions, and especially Illinois, have been host to a steady but relatively small number of food labeling class actions. But what we found in 2021 was, and it continues this year, was pretty startling. There's been a definite surge in the filing in Midwest jurisdictions, particularly Illinois. In 2021, there were 52 such class actions filed, of which 49 were in Illinois federal court. And breaking those down even further, the Illinois ones down even further, most of those were here in Chicago in the Northern District, but a sizable number, 13, were filed in the Southern District of Illinois, which includes certain counties that have historically been considered fairly pro-plaintiff.
Now, in your article, you mentioned that there were, I believe the total was 52 food labeling cases filed across the Midwest in 2021. Did those cases have any particular common characteristics?
Well, by far the most interesting thing and noteworthy feature of this surge has to do with who filed them, the plaintiff's counsel, because the vast majority of the new filings were from a single attorney. And interestingly, that was not a Midwestern or Chicago-based attorney. Instead, it's an attorney based in Long Island, whose name is Spencer Sheehan. There were certainly other counsel who filed individual cases, but Mr. Sheehan and local counsel with which he affiliated were the only repeat filers in 2021. And when I say repeat, I mean repeat because Mr. Sheehan personally filed 46 of the 52 cases filed in the Midwest in 2021, whereas in the year before, there was only one from him in these jurisdictions and none in Illinois. And, many of these cases are highly similar to other cases that he's filed in other jurisdictions. I guess the pejorative term would be a copycat lawsuit if you can copy yourself. He achieved notoriety by filing many so-called vanilla cases, which challenged food products that had the word vanilla on the label, with the allegation being that vanilla referred to an ingredient as opposed to a flavor and were misleading because the products didn't contain much of any actual vanilla.
Right. And actually, with regards to flavoring cases, it wasn't just vanilla, but he's gone on to file flavoring challenges for vanilla, chocolate, strawberry, fudge, honey, whole wheat, whole grain. Is there an end in sight? What is going to be the next flavor of the day?
Well, it's just a good question. And it does seem to be a flavor du jour kind of situation. He has not given up on vanilla. 4 or 5 of those cases in 2021 were about that. As you mentioned, chocolate, strawberry. For some reason, fudge is a particular target. That is the subject or was the subject of 7 cases. Ice cream bars dipped in chocolate is another one. So there's those. There are some variations on that theme. For example, he's filed a couple of cases involving the word smoked in connection with almonds and cheese. The allegation is there was only a smoked flavor and the product was not actually roasted over an open fire. And one of those actually has survived a motion to dismiss. And we'll talk about that in a bit. Other variations are that a claim that refers to a flavor implies a natural source for the flavor, and a reference to something like strawberry implies to the consumer that there won't be any other sort of similar product, so no apples or pears, or at least that's the allegation. Another type of claim that we're seeing here, these actually refer to cases other than the ones filed by Mr. Sheehan, have to do with the advertised number of servings, not so much the slack fill cases, but rather the number of servings that can be made from coffee, for example. And so far, anyway, Mr. Sheehan hasn't ventured into the sort of sustainability claims or claims of origin made in the USA type of claims, at least with respect to food that are being brought elsewhere. Although Mr. Sheehan does not limit himself to food claims, and he has brought claims regarding allegedly misleading labeling for some non-food products, although the food cases are where he focuses.
Yeah, we're definitely seeing some very interesting filings from him, and we're seeing a lot of the same trends that you are as well. In fact, we're currently working with various companies to help design and ensure some settlement structures and different types of the aforementioned matters that you discussed that actually have legs and have survived the dispositive motion stage and are actually heading towards class certification. Now, diving a little deeper into some of these, maybe I'll perhaps just stick with Mr. Sheehan. He went from not filing any cases in Illinois in 2020 to, as you mentioned, filing 46 food labeling cases and 18 other types of cases in Illinois in 2021. And I'm curious why the shift. Does Illinois have consumer protection laws that could be considered more lenient or perhaps even more plaintiff-friendly than California or New York?
Kevin, that's a really good and interesting question. Illinois' consumer fraud statute itself is not tougher. The liability threshold under that statute, the Illinois Consumer Fraud and Deceptive Business Practices Act, is not more lenient, or I'll say more stringent, depending on which perspective you're coming at it from, than the one in New York or California. All those statutes, like similar statutes in most states, rely on the same reasonable consumer acting reasonably in the circumstances standard. And in fact, under the Illinois statute, you can get punitive damages, but a commonly relied on New York provision, the New York General Business Law, Section 350, has a $500 per violation statutory damages award. So if a class were to get certified, those statutory damages can really add up quickly and become quite a sword dangling over a manufacturer's head. The Northern District of California became known as the food court because both plaintiffs and defendants viewed it as pro-plaintiff in these food labeling misrepresentation class actions. I'm not sure that that's what's going on here with this surge in Illinois. To be sure, there was a case decided by the Seventh Circuit in late 2020, Bell versus Publix, that you could be viewed as consumer friendly. It reversed a grant of a motion to dismiss a misrepresentation claim, and it held that for everyday low price items, in this case, packaged Parmesan cheese, a consumer doesn't have to read the side package ingredient list to clarify something that's ambiguous on the front of the label. But even that case still held that or reinforce that unreasonable or fanciful interpretations are subject to dismissal. And several district courts in the Seventh Circuit have taken that to heart and have dismissed unreasonable or fanciful claims. So at the end of the day, it's just, I guess, a form of speculation to try to get into the thought process that Mr. Sheehan is following, but it may just be that he's trying out a different audience.
That's what I was going to ask you next, was actually if that surge could be attributed to how the courts in California and New York ruled on motions to dismiss and motions for summary judgment in food labeling cases. But you're saying that there have been motions to dismiss filed in these cases in the Midwest as well, and several have been granted. So I think you're right that perhaps he's just testing the reception of the federal courts in different jurisdictions to hedge his bets.
Yeah, I think that's a good guess. He is a heavy filer, has been, continues to be a heavy filer in New York. And New York courts have not been particularly favorable to him. They've dismissed many, but certainly not all of his cases. So I think he is trying to test the waters somewhere else and at a minimum, hedge his bets. But based on the early returns, and we don't know the disposition of the many motions to dismiss that have been filed so far, but based on the early returns, it's not looking like Illinois federal courts are particularly more receptive to these claims than courts in, say, New York. Illinois courts have dismissed complaints filed by Mr. Sheehan, but interestingly, in doing so, they cite New York cases that perhaps Mr. Sheehan was trying to outrun, and that's kind of a function of the, I'll say, copycat phenomenon that I mentioned, or the fact that they're, if not exact copies, the claims tend to be very similar. So even though a court in Illinois is obviously not bound by what a district court in New York does, it can still be persuasive. And even a court that sustained one of Mr. Sheehan's complaints against a motion to dismiss, this involved smoked almonds, also looked at a similar New York decision that also denied a motion to dismiss. But, notwithstanding that, Mr. Sheehan is still filing cases in Illinois at a pretty steady clip. We're still tallying the numbers. We're planning a mid-year update to the article. But so far, by my count, he's filed 17 new food labeling cases so far in Illinois in 2022. We're, just past Mother's Day, as well as 4 other consumer goods cases.
So it sounds like the district courts in the various states around the country have all had somewhat similar rulings, but there are so many pending cases, and I would imagine pending motions to dismiss and upcoming ones as well, that we really have yet to see then how some of those decisions may impact the development of case law in this area. Would you agree? Yeah,
I think that's right. Based on what we have been saying, and here I'm talking about not just decisions that have come down in the Illinois cases that he's filed, but also cases or decisions out of courts in New York. What we're seeing is just sort of a continuation of existing trends, and there's not breaking of new ground, really. So, for example, the test is still whether the challenge part of the label would be misleading to a reasonable consumer or a significant proportion of consumers, which is not a majority, but just a significant portion, acting reasonably in the circumstances. And no court has, the cases are fact specific, or I guess I should say label specific and product specific. No court has announced a new rule requiring a greater degree of scrutiny from a reasonable consumer. And reading the decisions as they come down one by one, it's hard to see that courts are requiring that, although it's possible that when we're able to look back over the course of the year, a different picture might emerge. But, one thing that is clear is that dismissal orders have been outpacing orders denying motions to dismiss. And those cases, those opinions all say, well, a reasonable consumer's interpretation of a label is usually a question of fact, but then they go on to find that there's grounds for dismissal as a matter of law. So it's really not breaking new ground. It's more fleshing out what is or who is a reasonable consumer, what's expected of a reasonable consumer. And that hasn't really changed much, but there is some additional granularity to that, I'll say. So, at a higher level, there's a basic practicality that's required, a bit of everyday savvy. So the reasonable consumer will recognize what's purely fanciful. The classic example there is the Fruit Loops cereal. Nobody reasonably would think that it's going to actually contain fruit. Reasonable consumer will have to recognize or will recognize puffery. So, for example, a label that uses the phrase slightly sweet in a beverage will refer to a subjective taste, and a reasonable consumer will not understand that to be a representation about, for example, the amount of sugar in the product. A reasonable consumer will know that a reference to a flavor, such as the ones you listed before, strawberry, chocolate, vanilla, just talks about flavor and not ingredient. And by the same token, as I mentioned, the reasonable consumer will not be expected to have to decipher a highly unclear or ambiguous label, and won't be expected to, have to spend lots of time comparing the front to the ingredient list on the side.
And I think that's a very great and thorough analysis. And I think you've already probably answered the majority of this question, but just to bring the program to a conclusion, when you're working with your clients who are food and beverage manufacturers, what are the top things that you advise them to do or to avoid doing in order to hopefully avoid any potential exposure for food or beverage mislabeling?
Yeah, well, there's always a discussion with the marketing group about how aggressive a label can be or should be. And in that discussion, you've got to look at the entire context and contents of the label. Generally simple is better, at least from a defensibility perspective. For example, if you're talking about a flavor versus ingredient word, is there an image associated with it? It looks like from recent briefing I've seen on motions to dismiss, Mr. Sheehan is accepting the notion that the word vanilla alone, with nothing else, no other images, no other words, is just a reference to a flavor. But if you add a modifier like aged vanilla, then maybe you're not talking about a flavor anymore, and you're referring to an actual source of vanilla that might not be in the product, and that's a claim that has survived a motion to dismiss. So, consider those modifiers carefully. Sometimes they hurt or create risk, as in the case of aged vanilla, like I mentioned. In other cases, like the smoke case, you might want to add a modifier, which would be smoked flavor, as opposed to just smoked. And then finally, another type of case are these number of servings cases. The either up to servings, or actually Mr. Sheehan has filed a case regarding an ice cooler that talked about retaining ice for up to 5 days. And, you just need to be careful not to press it. You just need to be sure that there's not a great disparity between the number of servings or whatever the metric is on the label and what a typical consumer can achieve in their own home.
Thank you, John. Again, I think that's very great, thorough, and sound legal advice. So I think that concludes our program for the day. John, it was a great pleasure having you as my guest. I really want to thank you for your time and your valuable insights that you shared with our audience. Now, if anybody would like to contact you to discuss further any of the topics we covered here today, what would be the best way to reach you?
Best way would probably be email, jzabriskie@foley.com, or my phone number is 312-832-5199. I actually am frequently in the office.
Good to hear, and thank you for that. And I would also, of course, like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or to learn more about the litigation and settlement risk transfer solutions that are available for food labeling litigation, including our flagship product, Class Action Settlement Insurance, please visit the Risk Settlements website at www.risksettlements.com. And of course, you can always contact me directly at kevins@risksettlements.com or my direct dial, 216-570-9370. Thank you for listening, and until next time.